Hello and welcome back to the Clayden Principle for EPC Contracts. I'm John Clayden and this short talk is on the importance of notices together with a few practical tips. Generally, we think of notices as being issued by the contractor to the employer. But in its latest form, FIDIC 2017 also sets out the circumstances under which the employer has to give notice to the contractor. Whether you are a contractor or an employer, these notice requirements must be followed to the letter. The Obrascombe case was very interesting and is perhaps unique. In this it was held that the cut-off date for giving notice was not the occurrence of the event, or within X days thereof. Rather, it was held that the cut-off date was when the effect of the event commenced. Although I have used this ruling, see the next slide, in a recent delay claim, I advise most strongly that it is not to be relied upon. The case comes from 2014, and talking about clause 20.1 at the time, it was ruled that the clause was not to be construed strictly against the contractor, and that an entitlement to an extension begins when it is clear there will be a delay, or when a delay has begun to be incurred. Notice does not have to be given before that event. There's no need for a standard form of notice, but it must be recognisably a claim, and not, for example, as in this case, a monthly progress report. The onus is on the employer or engineer to establish that a notice has not been given in time. A defence against time bars for failing to give notice. Another tactic I employed in another delay claim recently was to argue that the imposition of liquidated damages was due to the minor breach of failing to give notice and not to contractor delay. That is to say, the trigger for liquidated damages was lack of notice. It was argued that the failure to comply with an administrative procedure led to the liquidated damages being unjustly imposed. The logic was that such failure was not a material breach, but a minor breach. As such, liquidated damages could not be imposed, as they constituted a penalty, which would not be enforceable under the governing law. Where we are now. Whilst those tactics may have been most engaging, they were, of course, employed somewhat in the manner of a desperate move to be used in cases where notices had not been properly given. The easy way to avoid resorting to such manipulation is to give notice of every little event. When the owner complains about such notices, answer, "I'm doing what you told me to do in the contract," which, by the way, was written by the employer. A few practical points. Before the works commence, The contract ought to be read very carefully to ensure that one understands how notices are to be served. Try and ascertain whether the notice requirements give rise to any conditions precedent by the use of words such as condition, subject to, or condition precedent. The obligation to notify the other party is not now limited to the contractor. There are occasions where the owner has to give notice too, and is mandatory in FIDIC 2017. It is useful to list these out and track them to ensure that the owner complies. I'll be doing separate videos on those requirements. A word of caution. Check carefully the time limits for effective notices, which would in any event be the earliest possible date. Try not to rely on the ruling of Oproscom. Be clear on the form the notice is to take. Notices have to be in writing. If no form is prescribed, describe the event or the circumstances relied on in as much detail as possible, and make it clear on the notice the event to which it relates under the contract. To avoid any later argument that notice has not been properly served, ensure that the notice is served in the correct way, at the address stated in the contract, and to the correct person, say to a director, project manager, or other senior personnel of the recipient as might be required by the contract. If you do not serve notices correctly, and your contract imposes a condition precedent in relation to the service of notice, you risk losing entitlement to additional time or money to which you might otherwise be entitled. This is the case even if the notice itself was valid and was served by the correct method on the correct person. So always proceed with care and expedition when issuing notices. If your notice is in connection with claiming an extension of time, the earliest it can be served is the earliest date on which it becomes clear that the works are or are likely to be delayed and will impact completion. To be on the safe side, make sure you notify as soon as it becomes likely or even possible that the works will be delayed. If you fail to notify and the delay has already begun, it may not be too late for you to notify, but again, you should always notify as soon as you can to avoid any criticism that your notification has come too late after the delay first began. Owners, employers often complain about notices from the contractor. But given that the requirements to notify typically include the mandatory shall notify, the simple response is, we are complying with the contract. Again, as always, thank you for watching. Please like, share if you wish, and subscribe.